What are the risks of being misclassified as a contractor? Imagine this. You show up to work every day, you follow a schedule your boss sets, you use their tools and equipment, and you answer to their supervisors. You do the same job as other people in the company, but when payday comes, you get a 1099 form instead of a W-2. Your employer calls you an independent contractor instead of an employee. Maybe they told you it means more freedom or higher take-home pay. Or maybe they didn't explain anything at all. But something feels off. You're realizing that you don't get health insurance, you don't get overtime, you don't get unemployment benefits, and your taxes suddenly look like a headache. This situation is incredibly common across construction, trucking, home care, hospitality, retail, warehouse work, and gig economy jobs. And workers often don't realize the risks until it's too late. Today, we're going to break down what misclassification really means and why it matters. The core issue in misclassification is this: what you are called is not what determines your rights. The law looks at the reality of the work, not the label on the paperwork. If a company controls your schedule, controls how you perform your work, provides tools, and expects ongoing work, the law is likely to view you as an employee, even if the company hands you a 1099 and calls you a contractor. Being misclassified may seem harmless at first. After all, cash may come in quickly, and maybe the employer makes promises like, "You'll save more since we don't take taxes out." But misclassification can lead to serious financial, tax, medical, and legal consequences. And most workers only find out when something goes wrong. Loss of overtime and minimum wage protections. Under the Fair Labor Standards Act, FLSA, employees are entitled to at least the federal minimum wage and time and a half pay for hours worked over 40 in a week. Independent contractors do not receive these protections. So if you're working 50 or 60 hours a week for a flat daily or weekly rate, misclassification could be costing you thousands of dollars per year in unpaid overtime. For example, a warehouse worker may be told they are a contractor and paid $700 a week. If they work 55 hours, that's about $12.72 an hour. Well below minimum wage in many states, plus no overtime. That is wage theft, and misclassification is how employers hide it. Loss of unemployment benefits. Employees who lose their jobs may qualify for unemployment insurance. Contractors do not. This becomes painfully clear in situations like layoffs, business closures, or seasonal downturns. When misclassified workers try to apply for unemployment, they hear, "There is no record of you as an employee." That's not because you didn't work, it's because the employer never paid into the unemployment system. And here's the key. If the state reviews your work conditions and determines you were an employee, the employer can be forced to pay back taxes and penalties. So even in unemployment disputes, misclassification can be reversed, but workers must know to challenge it. Loss of workers' compensation. If you get injured on the job, employees are generally covered by workers' compensation insurance. This covers medical bills and wages during recovery. Contractors are not automatically covered. So if a construction worker falls from scaffolding and is misclassified as a contractor, they may be left with no coverage, huge medical bills, and no income. We've seen workers in home health care injure their backs lifting patients, delivery drivers injured in traffic accidents, warehouse workers hurt using heavy equipment. All told, they were on their own financially because the employer labeled them contractors. Tax burden shifts to the worker. When you're an employee, your employer pays half of your Social Security and Medicare taxes. When you're misclassified, you pay both portions out of your income, the full 15.3% self-employment tax. That means a paycheck that looked bigger at first suddenly shrinks at tax time. Some workers don't file because they can't afford the bill. That can lead to penalties and debt, even though the situation wasn't their fault. The Internal Revenue Service, IRS, has clear guidance. If the company controls your work, you should be an employee, not a contractor. Misclassification can trigger audits and back tax assessments, usually against the employer, not you. But workers must be aware so they don't get scared into silence. Loss of legal protection against discrimination and retaliation. Employees are protected by federal anti-discrimination laws under Title VII, the ADA, and the ADEA. Contractors are not automatically protected in the same way. That means if you are harassed, threatened, unfairly disciplined, or fired for reporting wrongdoing, your ability to fight back depends heavily on whether the law recognizes you as an employee. Misclassification makes workers easier to exploit, which is why some employers do it intentionally. Loss of job stability and voice at work. When misclassified, workers can be fired instantly. No notice, no severance, no unemployment support. They may also be told they cannot discuss wages or organize. But the National Labor Relations Act, NLRA, protects the right to discuss working conditions, regardless of classification. Employers often mislead workers into thinking they have no voice. But the law does not let companies silence workers simply by calling them contractors. Why employers misclassify workers? Misclassification is not an accident in most cases. It's a business model. Companies do it to avoid taxes, avoid minimum wage and overtime, avoid providing benefits, avoid legal responsibility. It shifts cost and risk onto the worker while the company keeps the profit. It's not creative staffing. It's not industry standard. It's wage theft and tax evasion. You can challenge misclassification. Workers have the right to challenge their classification through the U.S. Department of Labor, state labor agencies, the IRS misclassification complaint process, private legal action. And here's something critical. Retaliation for speaking up is illegal. If an employer threatens, fires, or intimidates you for questioning classification, that's a separate violation with additional penalties. Workers often win back pay, overtime, tax reimbursements, and compensation for damages. The law is designed to correct misclassification, but workers must know that correction is possible. So, what are the risks of being misclassified as a contractor? You lose overtime, minimum wage protections, unemployment rights, workers' compensation, and employer-paid taxes. You may lose legal protections against discrimination and retaliation, and you may face unexpected tax burdens, all because of a label your employer chose, not the actual work you perform. But misclassification is not final, and it is not your fault. The law looks at how the work is done, not what the company calls you. If you believe you've been misclassified, you have the right to challenge it, to recover lost wages, and to protect yourself going forward. If this video helped clarify your rights, share it. When workers understand classification, they gain power, and power leads to fairness.